Uh-oh, you forgot to do something. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the SCAO form PC 600. SCAO for State Court Administrative Order, PC for Probate Court. And this is the form you never want to get. It's like getting the pink slip at work or the detention notice at school. It's a serious document. And the reason that you don't want to get it is it means that you've failed to perform a responsibility as the fiduciary. You failed to perform some required timing responsibility with the court, and you're going to get into additional problems if you fail to cure or correct the particular failure. Now, it can be used in a variety of contexts, which we're going to cover in a moment. With all of the SCAO forms, they are created by either statute or court rule or both, and this particular one is created by MCR 5.203. That particular court rule provides that the probate court is to notify fiduciaries of when they are deficient of a particular responsibility and give them an opportunity to cure or correct that deficiency. Now, failing to cure it can mean all sorts of things. It could mean you're suspended, you're sanctioned, you're surcharged, a special fiduciary is appointed. All sorts of bad things can occur. Also, one of the requirements under the court rule is for the court to not only notify you of the deficiency, but also to notify sureties, bonding companies, if there are any sureties involved. So this particular form, if you receive it, take it seriously and respond to it. Don't ignore it. So let's kind of understand how it's used and what it may apply to depending on the various contexts that you would receive it. Remember, this is not a form that you're creating. It's a form the court is creating, sending you notice that you are deficient. You've broken your duties, you've breached your duties, you've failed to do something you're required to do under statute or court rule. Top left corner will identify the court, top right corner the county. Now, often this form gets sent out by the court and it gets crossed in the mail. So you filed your document and the court sends out the notice almost at the same time. We see this happen a lot. Or maybe it got filed, but the court didn't docket it correctly. These are computer generated usually by the court, so they're fired out by a computer algorithm. So if the court doesn't recognize that you fulfilled the responsibility, it gets sent. So sometimes there are mistakes. It happens, but don't ignore it. If you receive it, don't assume it's a mistake. Make sure you've clarified that it is or was sent improperly. At the top, you'll see the court address as well as the estate name and then the recipient of the particular notice. Again, pretty intuitive. The next part identifies what the deficiency is. It says it appears from a review of the court file, and then there are lots of checkboxes. So let's cover each one of these one at a time. The first is when an inventory is filed in a deceased estate, the court has to have sufficient information to be able to determine the inventory fee that gets assessed to the probate estate and must be paid. So for example, if you file an inventory and it's blank, or you file no inventory or an inventory that doesn't give sufficient information, the court doesn't have enough information for it to assess the gross inventory fee. Second box would just simply be that the inventory hasn't been filed and it must be filed. Pretty straightforward. Next one is you've filed your inventory or presented under the statute your inventory, but you failed to pay the inventory fee. So you're delinquent in the payment, not in the filing or the presentation of the inventory, but rather in the payment. Money is owed. Next box relates to guardianships of minors, and this has to occur on an annual basis on the anniversary of the letters of guardianship for a minor. That box provides that you have failed to do your annual report. Pretty straightforward process, which we've explained in another video. File it, cure the deficiency. Next box relates to the annual report of an adult, legally incapacitated individual. That process, again, it's another type of annual report. And again, I've explained that in another video explaining how to complete that SCAO form. Next one is on a developmental disabled individual. These DD files, again, very similar reporting requirements on an anniversary basis for these files. The other is you may have done some other deficiency that the court required you to do, but there's no convenient checkbox, so the court can fill that section in. And the provision says that you are now notified. You have to correct it within 28 days from the date of the notice, not the date you received it, from the date of the notice. And you can always ask for an extension. The court rule does provide you can make an extension request, and the court can grant that extension for time. In addition, the court can impose a requirement for you to appear at a conference for an explanation of the status of that deficiency. So again, look at the particular checkboxes and any requirements or dates that are set forth there if the court is ordering you to appear at a memorandum or status conference. The next part is simply what I've been saying throughout the presentation of this particular SCAO form. Do not disregard the notice, because the court rules are in place to keep you in power, keep you in authority, and to ensure that you're fulfilling your responsibilities, your fiduciary responsibilities in that fiduciary role. Failure to do so can cause all sorts of problems for you. So if for some reason you can't fulfill the responsibility because of health or otherwise, advise the court, let the court know. Don't just ignore it. That will get you into all sorts of problems. Then there's a date provision there, and that date provision is set forth by the registrar or the court clerk. And the reason that date is really important is it's the 28-day time frame from that date that triggers the appointment of a special fiduciary, the suspensions, or whatever may occur thereafter. So it's 28 days from that date that's indicated there. In addition, the court is advising that if there are special disabilities or foreign language issues or otherwise, let the court become aware of it so the court can provide suitable accommodations for that issue. Again, most importantly, make sure that you don't disregard a notice of deficiency, because that notice of deficiency is step one to greater problems that will come on down the road. Now, with this is a good time to just suggest that whenever you're administering a guardianship, conservatorship, deceased estate, we strongly urge you to work with a skilled, competent probate lawyer, because these types of noticing and dates should be well understood by the probate lawyer. They may not be so intuitive to you, even though when you become the guardian, the conservator, the personal representative, all of those dates are set forth on that initial notice that the court gives you. So you have to calendar those dates and pay particular attention to those dates to avoid getting a notice of deficiency. At the Probate Pro, we are passionate about everything probate. If you have a question about a probate or trust related issue, or any questions at all, visit us at theprobatepro.com or call us at 1-833-PROBATE.